with the idea of using improper pronouns and so on in the case. It is not that he violated any policy. He's told the school district it would be a violation of his religious beliefs in order to comply. The school district is acting, and this litigation is based today upon the idea that he's already violated the policy. So what they're saying is that they're not really giving serious consideration to anything the public any input coming from the public. In fact, their lawyer argued today that the state law passed by the legislature a year ago requires them to adopt this policy, and that's not correct. The state law, which is a misguided, improper state law, requires them to adopt a policy. A policy. It does not require them to adopt this policy. They can adopt a policy that is more compassionate toward people who disagree and to give people alternatives. They do not have to adopt a draconian rule that if you disagree with the ideas that are embedded in this policy, that are embedded in the state law, that we're going to deny you the right to be employed. And so that's a material difference. And so the whole defense today is we don't have any real choices in this, but nonetheless, we're going to hold you accountable for violating an anticipated policy that we claim is the requirement of the state law. That's out of bounds. Even if all he got up and said is, I don't like the state law, it's a bad state law, no one should be required to apply it. Even if the state law required him to do this exactly. Free speech says you get to stand up and say, it is improper, the law is wrong, the law needs to be changed. I refuse to comply because he has the constitutional right to say those things. Moreover, the Sixth Circuit Court of Appeals, in a very similar case, the only difference was at the collegiate level, where a professor actually refused to comply with the policy. The court held that was a violation of his First Amendment rights for punishing him in light of the policy. In other words, he had the constitutional right not to comply with the policy. Why? The Constitution is highest law of the land. Policies are much lower down the constitutional scale. So the judge heard argument from both sides. Tyson Langhofer from Alliance Defending Freedom, who will be here in just a second, argued the case for ADF, and he'll be making remarks giving you more details. An attorney from Richmond appeared by video conference for the school district, but initially she only appeared specially, which means she wasn't admitting that the case was properly brought. They were arguing over whether or not the summons had been signed or not. The court read back the rule that does not require the summons to be signed by the clerk. It requires it to be issued by the clerk. The summons was stamped by the clerk. It was filed in the clerk's office. The clerk gave it a number, and the judge denied their attempt to use a technicality to avoid the Constitution of the United States. And it was a misplaced technicality, as it turned out. The school district then asked for a recess to decide whether they were going to defend the case. After a 10-minute recess, they decided they would defend the case, and the arguments they had made, I've represented in general terms their arguments, that these are mandated policies by the state, and anybody who, in anticipation of that, says, I'm not going to comply with the policy, if you get complaints about that fact, then that's a disruption, and we have no choice but to take you off your job. Now just think about this for a second. 5 parents had complained by the time they made the decision to take him and suspend him off his job. If 5 people complain about the school board members and they don't feel my kids are safe in the school run by you based on the statements you're making, do you think any of the school board members would resign because of 5 complaints or 50 complaints or 500 complaints or 5,000 complaints? Of course not. Because hecklers' vetoes are not the way you run a school district. You have a duty to stand up to parents and say, we appreciate your views, we'll do everything we can to accommodate you, but you do not get to decide school policy, and you do not get to decide that we're going to violate other people's constitutional rights. They have a duty to stand up for their staff, not the duty to run away at the last minute. I believe that the judge listened very carefully. He did a great job of asking probing questions of both sides. He made it clear that he was going to go read the cases filed by all sides, and that's all you can ask of a trial judge. It was an exemplary hearing in all respects. He was patient with everyone, and so it would be improper for me to speculate, although I would just say every case I've ever argued myself, I always thought I was going to win except one or two. So we can't go by my gut feelings because I'm just too much of an optimist. But I have argued in the Supreme Court of the United States, and I've argued in courts all up and down this country, and I can tell you, based on over 40 years of legal experience, the judge did a great job today, and we should have to be thankful for a judge that did such an exemplary job of being an even-handed arbiter of the law and the facts. And so for that, I'm very, very grateful. It looks like we've got our people here, and so God bless you.